Let's fill out an Oregon prenuptial agreement together and check off every legal requirement as we go. This is Oregon's prenuptial agreement, the contract a couple signs before marrying to set their own financial rules. On the right is everything Oregon asks of it. The agreement has to be in writing, and that is the document in front of you. This is a contract between two people planning to marry, made ahead of the marriage and effective when it happens. Start with the effective date, the day the couple plans to sign before their wedding. Type the month, day, and year here. Signing does not switch it on, it takes effect when the marriage happens. Any deadline to bring a claim under the agreement is paused for as long as the couple stays married. Subject to the fairness defenses state law leaves open. If the marriage turns out to be void, the agreement holds only as far as needed to avoid an unfair result. Next, enter each prospective spouse's name and mailing address, exactly as they will appear on the signed pages. The agreement calls them Prospective Spouse 1 and Prospective Spouse 2, names carried through the signature block and the schedules ahead. Each person has to sign it of their own free will. An agreement someone did not sign voluntarily does not hold against them. Neither person owes the other any payment or promise for this to hold. The marriage itself is the exchange. Further down, a clause names which state's law governs the agreement and which state's courts would hear a dispute. This is an Oregon agreement, so both blanks say Oregon. The couple can pick which law governs the agreement. The attached schedule lists each person's finances. Spouse 1's copy shows a bank account, a car, and some jewelry as examples. State law sets how each person discloses what they own and owe, and what happens to the agreement if they do not. It can set each person's rights in any property, no matter when they got it. It can cover the right to buy, sell, use, and manage property. It can set how property is divided on separation, divorce, or death. That disclosure can be waived only if the person does it voluntarily and expressly, in writing. Spouse 2's copy follows the identical layout, with a different sample balance, vehicle, and valuable item. It can change or drop spousal support. It can require a will or a trust to carry out what the couple agreed. It can say who owns a life insurance policy and who gets the death benefit. Anything else can go in too, as long as it does not break public policy or a criminal law. A support waiver cannot push someone onto public assistance. A court can order support to the extent needed to avoid that. The agreement closes with a signature line and a dated line for each spouse. Both people have to sign it, so neither page stands alone. It cannot touch a child's right to support. The couple cannot sign that away or trim it. Once it is in effect, changing or canceling, it takes a later written agreement signed by both. A spoken change or a one-sided cancellation does nothing. The court decides whether the agreement is unconscionable, and it decides it as a question of law. Either side still has the usual fairness defenses, like waiting too long to enforce. Fill out your own prenuptial agreement free at FormsPal, no sign-up required.